If you can't be fearless, if you can't be independent, then you're not worth the gown. All these cases of possession of drugs do not have to go to court. You can divert this. These are drug addicts. They need treatment. Legal profession is taking the wrong direction.
Mr. Boolell, welcome.
Thank you. Thank you for extending this invitation and for welcoming me in your lovely chambers, prison chambers.
Thank you.
And I'm glad to see that it's an all-girls powerhouse.
Almost, there's one man.
Okay.
It's the minority.
An all-girl majority powerhouse.
Exactly. And Happy New Year also.
Same to you and to your colleagues.
Thank you. I hope you had some time to play some golf over the festive season.
Yes, that's the best occasion during the festive season to play golf, but it's too much sun also. That's
yes, it's very, very hot at the moment. And actually, if you don't mind, that was going to be my first question, just to kind of break from the convention a little bit. If you hadn't been a lawyer, what would you have been?
You know, I love football. I would have loved to be a professional footballer.
Okay.
But I know this is something which I could not realize. But, you know, there are other exciting professions. I mean, I like to be a professional photographer. Is very artistic and creative job to do, especially if you want to shoot wildlife. Writing, journalists, reporting, all these are exciting things because you're in control of what you want to do. But the bottom line for me is not to be employed. But in my case, I've been employed for the last 40 years.
With the same employer.
With the same employer.
And was that a choice? But if we go back to when you were studying, did you feel compelled, not forced, but did you feel compelled to go into law?
No. You see, I started doing economics with my studies. But I must tell you, I was always surrounded by lawyers. My father is a barrister. My cousins, Vinod Boolell, his brother, Prakash Boolell, they were all barristers. And I was always interested to hear them discussing law or having exchanges, sharing the courtroom dramas. And I was also given by my father a book as a gift.
Okay. To
Kill a Mockingbird by Harper Lee.
I love that book.
And I thought, look at the power of justice and the power of the advocate to ascertain the truth and justice, to set, the record as to this kind of injustice against someone because he was black, and the false allegations against him. I thought the barrister is a privileged person. The barrister is someone who stands in the middle of the state and the citizen. And that's very important because that is the essence of freedom and liberty. Because if the state wants to crush this citizen, the barrister is there, is available. He is fearless.
Yes.
In the discharge of his profession, and he's independent. He has to see to it that there's no injustice, there's no unfair way of dealing with the citizen, and that's what better cause do you want? So this is why I think the profession, the legal profession, the barrister, the role of the barrister is is something so, it's a privilege to wear this gown. I have had a long career, and I've really enjoyed being in court, taking lots of challenges, and as a barrister, I think it is something which have given me a lot of job satisfaction.
Yes. We'll delve into the nitty-gritty of your illustrious career, but did you feel with over, decades of practicing criminal law that because what you said, I agree with everything that you said, but it's easier said than done. Did you feel you were always able to stand true to those principles and to do your job without fear or favor?
Yes, but that's what our code of ethics tells us. Because if you can't be fearless, if you can't be independent, then you're not worth the gown.
Yes.
Your duty, first and foremost, is to the court and then to your client. You serve two masters, the client and the court. The court, the duty to the court to ascertain the truth, to ascertain justice, takes precedence over your duty to your client. And you are not the mouthpiece of your client. I said that when the last time I was delivering a paper at the bar conference. You are not the mouthpiece, and you should not associate yourself, whatever be the cause, whatever be the issues about your client. This is for the court to decide, but you have to defend and assist in ascertaining where is the truth and where is justice. So I keep saying that because this is at the very core of what we stand for as barristers. And I have been guided. I was DPP, I have had to take difficult decisions. I was at the Attorney General's office. We've had to deal with many interesting issues, many difficult issues. And right now something is coming up in my head. It's a case where it involved an Indian Army officer.
Right, okay.
Who was a helicopter pilot. Amongst the many cases I've done, this case
stands out the most.
Which I did not conduct.
Okay.
And it stands out the most because we are here dealing with an Indian Army officer who is accused of having sexually molested a girl aged, I think, 11 years old, a minor. Now, the police started an inquiry. He was living in quarters in Riverwalk. And on the basis of the medical examination of that girl, on the basis of the police inquiry and the different times that, because he was staying in the quarters, he was alone. His wife had gone.
Okay.
And the girl used to go there, lured by, I think, a cat, to go and play with a cat and so on. And on this sad day, so she was a victim of sexual molestation. But the thing is, when we referred the matter to court, or there was an attempt to start an inquiry calling this suspect, and I must finish this story because the outcome is something important to say. Then the Indian government walks in and says that the army officer is entitled to immunity because and it's not only for India, for the US also. They don't submit themselves to any jurisdiction except to court-martial.
Wherever they are in the world.
Wherever they are in the world.
Right.
It's the same for the Americans. But then, for me, as a young law officer, I thought
terribly unjust and unfair.
It was terribly unjust. Immunity to discharge your function, but not to go outside the purview of what the scope of what you're supposed to do. Now, and it had serious repercussions because there was, and I must say the DPP then was very supportive, but there were issues regarding this immunity. And I insisted, I said, let us look at this document. There was never any document. We got a document regarding the Indian naval officers, not army officers,
Right.
which was linked to a boat which was manned by the Indian naval officers.
So it had nothing to do with an army officer?
Nothing to do, and then there was no document. But they wanted to extend that. What happened is that we lodged the information. The case went to court, and I remember the Madame Gajadar, who is a QC, appeared for the Indian High Commission, and they came with a letter from our own Ministry of Foreign Affairs, which he produced to court. I said, I've never taken cognizance of this. And I must say there were a lot of things going on between this office and the executive, the Home Secretary here. There was at the time...
Had become a sort of international incident, if you will.
Between two
India
states.
and Mauritius, yes. Yeah.
And I suspect, I was even told that this will have serious diplomatic repercussions. But at the end of the day, the whole thing was frozen because of, you had the executive, you had the independence of the DPP, and you had the judiciary. Now, before the court, the intermediate court said that they think that the document was valid. So that froze our action, and I felt that the rule of law was being sold to the Indian army. But that the Indian government did not stop there. They decided to hold a court-martial in India, in New Delhi. So the whole lot, the victim, the forensic, the police officer, everyone flew there. But the case was dismissed. We didn't have any audience there. It was done by the army people on the ground that the officer was framed on the grounds that as helicopter pilot, he was detecting a lot of drug plantation in some of the remote forests of Mauritius. Now, I accept this. I'm not going to comment whether this was, but this is a fact. But I felt that this is an important case. You've had the interaction, the executive, the judiciary, and the independence of the DPP, and the fact that you've had a foreign country and
interfering, if I may use that word,
and which halted the rule of law in a way. But I thought there were many interesting legal issues. And so this is something which was an interesting case. Unfortunately, we did not have sufficient jurisprudence before our court. But it's an interesting case, and I suppose similar issues have been risen elsewhere.
Yes.
And then there's another interesting case which I did, which also struck me at the time before the assizes, was the little girl, again.
Was that the 8-year-old?
8-year-old girl, who, because she didn't have her uniform, they had just washed her uniform and it was wet. She didn't have the uniform to go to school. Right. So she stayed at home. And this was the day they raped, sodomized the girl, and they murdered her. So that was a heartbreaking case because this girl, fate was on the fact that she had only one pair of uniform. And
presumably because of means.
She was a poor girl. But
Please tell me that they didn't get away with it on this occasion.
they were all sentenced, and I must say it was one of the accused was defended by Antoine Domingue. So, and everyone was accusing the other, but we had a lesser offense, and so we brought one of the co-accused as a witness. But interestingly, I went to see the Chief Justice, and the judge agreed that we hold the first trial where this accused pleaded guilty, and the next day he would come as my witness. So that he would not have any interest to serve. He has already been sentenced. But thanks to his testimony before the jury, we managed to
get the others as well.
To get the others. So these are two cases that I always, but there are many other cases.
I mean, you've been to the assizes many times. How do you, and I always ask that question to criminal lawyers. I mean, as you said, the murder of the 8-year-old girl, heartbreaking. She got some justice in the end because they were found guilty. But how do you, or do you detach emotionally?
It's difficult to, you cannot, well, you must not be emotionally involved or you must not be, you must be a case lawyer, not involved with all the circumstances of the case, because otherwise, if you become too passionate, then you clog your objectivity, your impartiality, your independence.
Sure.
But I think once you have a case and you feel strongly about it, it's the way you have to translate the case to the jury. It's the way you have to impart the circumstances of that case. You have to have a good story to tell. You have to stitch a very strong, bulletproof case, because the defense would always want to create a doubt in any move that you make. And that's their job.
And then the threshold is beyond reasonable doubt. Yes. So you only need to do that.
Absolutely.
As it were.
Yeah. So you have to ensure that whatever you say or whatever you adduce as evidence will pass the test of beyond reasonable doubt. And that's the thing. And one of the things I used to do is when I have read a file, I felt it was important to go and make sure that the culprit is punished. I would start working on my submission, because the submission is what is your last nail that you have to.
So you start with the end, as it were.
I start with the end and work from that backwards to the evidence. Think about it. If I'm going to tell it that there was an accident and the man crossed the road negligently, I will have to adduce every bit of what I'll be saying at the end. I have to make sure that the evidence is there. That's what the case for the prosecution should be. You have to ensure that all the evidence is there. And the second thing that I used to ensure that I was really on top of my brief was to anticipate the defense.
Yes.
And during my submission, I would already say that in a minute you're going to hear my learned
say
friend
so and so.
Tell you this and this. So I would try to dilute it. I'm not saying it's always perfect, it works or it doesn't work, but there must be some form of methodology in the way you want to, especially when you deal with a jury. So you have to build it,
yes,
brick by brick to sort of come to converge to an apex, and then you have to be convincing, they have to believe in you. So I think today the court process has to be balanced, because I find it incredible that we still have ambush defenses. The prosecution has to ensure that they have a very efficient disclosure process. Disclose the whole case, good, bad, against them, in their everything.
No last minute surprises.
And the more that it may help the defense, the more they must ensure that this is disclosed to the other side. And at the very early stage. You cannot come at a late stage and say, well, this escaped my mind. This would be a miscarriage of justice. But at the same time, we cannot have ambush defenses. This doesn't work. If we have to practice the equality of arms, as our Section 10 of the Constitution tells us, for the protection of a suspect or an accused party. So it has to be a fairly balanced, because in that equation, am I raising my voice? In that equation,
not at all. You're passionate about what you're saying.
You also have the victims. You also have the victims. And so you have to ensure that the process evolves, And, recently, if you've read the press, and a number of young barristers have expressed their views on the question of delay.
It's a huge issue.
It's a huge issue for all of us. But not only, we should not lay the blame at the doorstep
of the judiciary, necessarily.
It's all of us.
It's the whole system.
It's the whole system. But what are the consequences of this delay? It's the quality of the justice which suffers. If you have a witness that comes to court after 5 years, what would you expect? He would have he may be disinterested in the matter. We don't have a witness support system. And you know what? Many of the accused, and it's sad to say, in many of the atrocious crimes, they thrive on that delay, because in the hope that these witnesses would drop out of the system, and they would get a dismissal. So it's something which if we want to be people to have confidence in the system, if we want our system of justice to be on the international best practice, if we want this judiciary to be this jewel in the democracy, we must, we cannot turn a blind eye. I know the court is creaking, there are backlogs there, but we have to sit down and ask ourselves, where are we going? We have many barristers.
Over 1,000.
The profession is growing, but the quality of the justice is not. is going backward. Perhaps I would say, let's start having a proper toilet facilities, restroom in the
air conditioning.
But we have to think seriously, and the legal profession, the judiciary, the state law office. We have a new Attorney General. He's too well aware of all these issues. So let's just hope that things will improve in the name of public interest, in the name of a more efficient justice system.
Yeah. I agree, and I'm always, I wouldn't say ashamed, that's too strong a word, but whenever I find the time to read some of our Privy Council judgments, very often I see some sort of remark about the amount of when the case started and when it's reached, and I think that's very telling. And again, it's not an attack by any means on the judiciary; it's the whole system.
But they've been saying that for more than a few decades. Yeah. That's the But when I was DPP, I advocated a number of things, and I am perplexed why governments, successive governments, they are so excited about enacting legislation. For anything
it's easy to enact legislation.
They enact a piece of legislation, whether you have to wake up on which leg, there can be a piece of loafer. But why they turn always, they remain indifferent to so many things that could have improved, unclogged the justice, our courtrooms. Let me give you an example. All these cases of possession of drugs do not have to go to courts. You can divert this. These are drug addicts. They need treatment. They don't need...
They need support, they need help, they need therapy.
And they need our efforts to bring them back to society, to rehabilitate them. The prison system today, I don't know whether 3,000 or 4,000 prisoners, 90% or more become reoffenders. So
there's no rehabilitation.
No. The rehabilitation is not working. People who have a tag of being an offender, they are left on their own. No employer wants to employ them.
Yes. That is maybe something that might be changed in the law as well. I'm not saying that you erase everything, but I was helping someone the other day and he'd done something in his youth in 1997. But because the law is drafted as it is, it's still in his certificat de moralité, and he will forever be unless the president decides to, exercises the discretion that it.
But I was reading something that Richard Branson, the owner of Virgin, and he was encouraging employers to employ offenders. He argued that we've done it as employers. These people, they will be ever grateful if you give them a second chance.
Yes.
They will be loyal. They will realize that you are giving them a second chance in life. We should encourage this system of rehabilitation or diversion, community service work. Prison is a sad place. It's a disgrace. It's not a place that we just, sometimes people on the bench are like small emperors. They sent to jail. They want, it must be the last resort, and we must encourage people to divert them to programs for rehabilitation. And you remove all these drug cases.
And it frees up all these resources for the cases that matter.
You get a few grams of, powder. This has to go to FSL. You get thousands of this, and FSL will take God knows how long. The inquiry that we still, shorthand writing, not shorthand, longhand writing, and with a pen, this inquiry, the file will be ready in 1 year. But we have to change the system.
Yeah. And
also, the world is going to artificial intelligence, and we're still sitting down and taking statements.
Written by hand.
Written statement by hand.
Even the law lords before the Privy Council said, I don't want to see any paper, I'm working off an electronic bundle, and that's the only thing I look at.
They look at screens. Yeah. They handle thousands of pages, but sincerely, I don't know what is happening to our system. Maybe I can understand judges are busy with their work. There's no time to think about the process, the administration. There's perhaps no one, who expects a judge cannot convert himself into a
policymaker,
or a manager of court systems. So we have to start seriously considering introducing technology, streamlining the process, enhancing the training, diverting the system to alternative dispute resolutions, to all kind of in some countries they've introduced restorative justice. We must unclog the court. There are many minor offenses which we can decriminalize. There are many offenses we don't have to send to prison. Divert it. And we should also put more emphasis on training, on ethics, on the way the court system to increase the quality. But let me add something. Our criminal code. Mm-hmm. We're still using the code of 1810 of the 17th century.
Yeah.
Right? At the time, the French Revolution, we had Déclaration des droits de l'homme et du citoyen. In, I think, 91, we have such a rich legacy of jurisprudence. And we are not making the most. We have a legacy of judicial inquiry from the. When are we going to change hearsay? We have a legacy of debene on our books. What are we doing with hearsay? Bad character. Well, the whole procedure, evidence, all is antiquated, rusty. You would know.
Yeah.
Can you believe that in this day and age, someone has given a statement, and if he's not present, let's say a banker, I remember we had a case, a banker from France came to give a statement. He was waiting, point of law, postponement, point of law. The guy says, look, I can't stay. You have a beautiful country, but I can't stay here for the rest of my life. I have to go, I have work to do, I have family. So he left. And because that statement could not be used, the case collapses.
Are you allowed to have video hearings by way of video conference now for criminal law?
In some cases only.
Okay.
We should extend it to all
course.
cases. We should extend it to any case.
What baffles me is that actually we did make some progress during COVID because we had no other choice.
Yes.
And then once COVID went away, we went back to our old ways as if we were more comfortable with something that is, I'm just drawing an analogy to tax law because that's what I do, is that we had ARC hearings by way of video conference during COVID and now we don't anymore.
I did a Privy Council case, the case of Lages. I was sitting in my office. It was amazing. I was in my office.
Yeah.
I was addressing, and I had my assistant there. Anything, and they were assisting me with authorities and so on. I thought it was marvelous.
Yeah.
But it was time consuming, money saved, and so on. So I think we are not serious. We have to wake up. This is an alarm. Right now, why don't we, for some cases, don't we have what they call the Nightingale courts, evening courts? Why do we have to tax people and victims with such an onerous procedure? Why do we have to make people sort of make it a nightmare? Court system becomes a nightmare. All I'm saying, and I've seen a lot of the proposals made by young barristers, that there's hope. They themselves, they have come up with a number of suggestions. And it's a bit of we need some political will. We will be there. And, I'm also, there's a perception also that the judiciary lives in a parda, behind a parda. A parda is a screen of goat skin, you know, in some societies in India and in the Mughal Empire they use that. But it's as if there are lots of things that go on and they're isolating themselves. The whole profession should sit down and see how best to get things moving.
Together. And
Yes.
it's for the common good, not just to make our lives easier, but to make the whole society's life easier.
Of course. I think there's a lot of scope. There's a lot of good suggestions. There are a lot of things that can be said and made. But we have to do it. I think we will have to also perhaps the Bar Council, the Mauritius Bar Association Act will have to be revised, enhanced. We need a proper secretariat. We need people. They must get funding. They must be able to give papers. The Law Reform Commission will be important. We have the IGLS, Institute of Judicial, not IGLS, the training.
Yes.
So I hope all these, we have some senior judges, they can contribute, so all these, you know, we can produce a blueprint, we can have a roadmap how to get things, because at the end of the day, the consumers of justice are the most important protagonist in the whole justice system. So that's what we should be looking into. Yes, I've been a bit
I'm fascinated by what you've shared, and it kind of, I'd like to rejoin that to you. You've spoken a bit about the young generation, what they can contribute. As you said, you rightly mentioned, we have a lot of barristers in Mauritius, I think over 1,000. A lot of the newcomers, they feel, I wouldn't say lost, but to some extent I think they feel that there's a sort of lack of mentoring, that it's a kind of dog-eat-dog world, especially in Port Louis, especially in criminal law when you're a defense barrister. So what advice would you have to give to them?
You know, mentoring or pupillage is not an option, it's a duty. It's provided in your code of ethics. So I remember when I was DPP, I opened the office of the DPP to take on young members of the bar who wanted to understand what is the work of the office of the DPP, and they were people who were going to court. They were writing in our newsletter. They were doing podcasts, interviewing me. So I think we should encourage that. We should inculcate that. The difficulty today, legal profession is taking the wrong direction and becoming a legal business.
I agree.
It's becoming a legal business. Profits is superseding ethics. And there has been no structure. We have many barristers. We have made a leapfrog from, the small barrister's office.
Chambers.
Into chambers.
Now law firms.
Law firms. And I think we are not sufficiently structured as to how to recruit people, as to how to ensure that there is a duty to mentor, a duty that you have a checklist of what is being achieved. So all these, c'est un peu à peu près.
Yes.
That's the
danger.
So the danger. Yeah. And there's a rush for money, for survival, and that can be difficult because there's no also work is not also available. It's not democratically also. Sometimes merits become very down on the list. So we have to understand how we promote the merits of our young barristers, we give them opportunities, and also we enhance the quality of justice. So all these go hand in hand, but it's not good sitting here and saying these things.
Yeah.
We have to address those issues.
To actually do it.
Maybe we should have a commission like we had the Mackay report. Maybe we should get people who have experience in the field. UK is fertile ground because they have similar issues as ours. They can act as a model for us. Maybe someone can come write a report, and because Mackay has taken our hand and many things have happened.
Yes.
Albeit across a long span of time.
Sure.
But
yeah.
At least in the right direction. At least in the right direction. So maybe we should try to first we have to accept that, look, we have to improve. We have to help how do we get the new entrants, and it starts from the education that you give to barristers, not from the day they walk into the profession. It's from the day they enroll at the university or whatever university.
I agree. Yeah.
It starts there. And sometimes when we studied in UK, we were ill-equipped to join the Mauritian bar. The whole civil system was based on Code Napoleon. I've never opened a Code Napoleon.
Did you come straight back after your studies?
Yeah. I
Must
came
have been a
straight
shock
back.
to the system.
That's why I was encouraged to join the state law office, and it was the best
school.
Best school.
Yeah.
I remember I think it was former Chief Justice Rangapili was a gentleman. Okay. And my first week gave me a case file, which was I think it was a case of writ abere fastas possessionem or something. And I said, I
don't know what to do with that.
I don't know. He said, take 24 hours or 48 hours if you want, and then you'll become an expert in that. So that was the way you had to go and learn and discover about, what's the juge en chambre and, all these things. And so it's something that we have to inculcate. I mean, the University of Mauritius did a good thing. The law faculty was prepared well, but we have to, and it's a good thing that people now have to have the 1 year full pupillage. It's time for them to absorb and adjust to the profession. Yes, it's a good thing. So let's hope the young themselves will come, and I think they are dynamic people, they are interesting people, they will come with a lot of solutions. Maybe they will tell us how to introduce AI.
Yes.
Everything is electronic. The research we do is electronic. The presentation in the courtroom can be electronic. So all these, maybe people will how to decide on issues. So
I think there needs to be a balance. There needs to be a balance between the very experienced and the young generation, and hopefully, we see that government is trying to do that at the moment. But apart from that, there has to be, the experience and wisdom of the old generation with the new ideas and creativity. You mentioned creativity earlier of the young generation. See what they have to offer.
Obviously.
My daughter's just started a new school, and she came home with, I grew up with pen and paper, with slate when we were in primary, and they're just using a tablet now. And I struggle with that. Maybe I'm getting old, but I've always learned best by writing. But then I have to come to grips with the idea that maybe the next generation is growing up in a different way, and we have to embrace that.
I think artificial intelligence is going to have a tremendous impact on the way even the whole administration, whether it's government or the system of justice, we will have to adapt. Already people are using opinions from artificial intelligence and putting that before the court in some jurisdictions. I don't know about Mauritius, but in some jurisdictions, I know in the States, in UK, they are having recourse to artificial intelligence.
Yes, they are.
So we have to accept, we must not have a declining mentality. This is a disease that we suffer here, a declining mentality. Everything
has to be just as it was. Yeah.
We must be able to move ahead, to accept that changes will be painful, there will be mistakes, but the world is moving very fast. So we used to take a lot of pride about we are a step ahead in the region, and we are showing the way. This is no longer the case.
No longer the case. We're no longer number one on the Moe Brahim Index for good governance in Africa, which I thought in itself I found that devastating, to be honest. We probably rested on our laurels and became complacent. I mean, you probably were still DPP at the time we were on the infamous blacklist, if I'm not mistaken.
I think people were, constitutionally illiterate. Those who were at the helm of power, they suffer from this illiteracy. I'll tell you why. If you look at and we have the sessional papers to back what I'm saying. A bit like the Federalist Papers of the United States Constitution, but it's not necessarily. But when we had independence, when we had the Constitution during this time, all parties, different parties, and Mauritius was divided. It's a fact. But all the leaders from all parties, they sat around a table. They did realize that for Mauritius to work, there must be a balance. This is why a number of institutions, the Director of Audit, the Electoral Supervisory Commission, the Electoral Commissioner, the Office of the DPP, all these were given a constitutional status of independence. Even the Commissioner of Police in his operational matters, because you know why? Some people were scared for their safety. They said, we do not know, because there were a lot of propagandas.
I'm sure.
There were a lot of propaganda. Be careful.
On both sides, I'm sure.
There will be a sort of majority which would, oppress a minority. But the leaders,
they put safeguards in place.
They put safeguards. They say, this is what would help Mauritius to work, that there would not be interference in the institutions. Institutions will be the only guarantee for the PSC, Public Service Commission, the Local Government Service Commission, the DFSC for the Disciplinary Force Service Commission, and so on, because they wanted the country to reflect this rainbow nation that we are, and that you should not, otherwise you would have this temptation of creating an autocracy, a totalitarian state. This is why, to come in full circle, the work of the barrister, which stands against this oppressive shadow of the state, is crucial. Because, in that constitution, take Article 5, the guarantee for our liberty and freedom. Take Article 10, the protection of the individual when he's faced with an accusation. Take this whole chapter of human rights, the chapter 2. So these are entrenched guarantees in the Constitution because we wanted to create this Mauritius, independent democratic state where the rule of law prevails and the separation of powers. And this separation of powers was undermined, was put in danger. That's why the Mauritian people reacted as one
strongly.
nation. You see, don't play with our freedom, our liberty. This has been a long history. And I can tell you something which I will always remember for the rest of my life. Because I walked in the crowd on the 11th of November and I saw Mauritius.
The flag, the national flag. You didn't see flags of red, purple, yellow.
People were singing the national anthem. This was the nationhood that we had prayed
along the way, maybe a little bit.
That we had prayed that would emerge. Maybe it took half a century
to get there.
But I saw it, and I can tell you, many people shared that feeling with me. So,
and the beauty of it, and I always come back to that because I've always been a politically neutral person, and I still am. But the beauty of it was that feeling of the people who you were seeing on the streets or people who you talk to generally, they all said, well, not all, but a lot of them said, I have no political allegiance, but I love my country.
Absolutely.
Yeah.
But this is what politics is about. The love of your country is a political statement in itself. So, but it was good to see everyone. It's as if, the other time that you see this kind of bonding is in sports. When we are having...
brings everyone together.
Yeah. Sports.
In football as well. May I ask what your team is?
My
your English team, sorry.
I have many English teams. I'm not the... I like Chelsea, Tottenham, Manchester United.
So you don't have a single one. But yeah, to come back to what you were saying, yes, it brings people together across all socio-economic backgrounds, ethnicity.
Yes, and this is what we are. This is what I think we should consolidate and move. It's such a it's so rich culturally, so rich spiritually. So when people say that we live in a paradise, we should not take that lightly.
Yes, indeed. I have a last question for you. I could go on for hours, but I know that you're a very busy man. And it's unrelated to the barrister job, but maybe there is a link to it. Your love of writing. You have written a book recently with the help of Alain Gordon-Gentil, who I love. I think he is such a beautiful writer. What inspired you to do that, and how easy or difficult was the process?
When I left the office of the DP, for me it was a closed chapter. But then I think Alain Gordon-Gentil came to see me and said that at least there are many interesting chapters in this span of your career, and you must be the only DPP who was subject of an arrest your whole place was surrounded by the police, and that you've put up a fight, brave fight, and you've so it is something to be told. It's an institution, and it should be told. It should go on record. So it started
planting the seed in your mind.
Planting the seed. So
yeah.
Gradually, I thought, yes, and there have been many issues, amongst which in that book there's also the Chagos Archipelago, which I have worked as a law officer. I was parliamentary counsel. I worked with Ian Brownlee. Mm-hmm. So, and he was a fascinating man. He was, for me, he was the father of modern international law. I was liaising with him, and I think the outcome before the ICJ was, in my view, he's the architect for this. So there were many interesting things happening. There were many, I worked with Sir Victor Glover, who was former Chief Justice. We worked as colleagues for drafting legislation. He was a fascinating person. He was a very, no ego, nothing. He would just be your friend.
Very
humble person. And we did a lot of interesting piece of legislation. Even today, to say that all the owners of these long-tail houses, we were always a legal conundrum, but Sir Victor would always come with a solution. So all these things affect people's lives. And I think if there are things that you've done and affect people's lives in a positive way, in a constructive way, that will impede on different generations, I think it's worth telling that story for the sake of your country.
So a legacy of some sort.
A legacy of some sort, yes.
Wonderful. What a wonderful note to finish the podcast. Thank you so much. I have other questions, but maybe we'll leave that for the next time once I've read your book, and then we can talk about the book and the various chapters. Thank you. One last question for you. And you probably answered it throughout the podcast, but maybe if you could just summarize it in a few lines. What do you think your purpose in life is?
It's a hard question. You want to be fulfilled. You have a family. You want to
Your grandfather.
To be a good grandfather, a good father. You hope that you've had your mission of inculcating the right values to your children, to the family, and that you've managed to, not only the family, and I must say I have a very special wife who looks after me very well.
That's lovely.
But to be happy and to make people happy and to have a good heart. That's all. I don't think it's already a tall order.
Exactly.
To be good.
Yes. To
give, and if you can give. You know, in our family, and my grandmother, and part of us, we were doing the charitable work because of the values of the Arya Samajist movement that, and you know the Gaya Singh convent?
No, I don't.
In Port Louis.
Okay.
That was something which was founded by the aunt of Mrs. Boolell and her husband, the Pandit Gaya Singh. So it's always been how to give and how to do some charitable work, how to share, and so I think that's, I say a lot of that in my brother, who's a politician, and how to, you must learn to give also. So I think these are important to be of service, and the rest is in the hands of someone else.
Yes, indeed. Thank you so much.
Good.